Hi, my name is Baldev Binder and welcome to our video series on legal issues affecting your business. Today I'll be talking to you about what's been occupying the headlines in the press: insolvency and restructuring in Singapore. What is a JM? What is a scheme of arrangement? How does a moratorium apply? What can I do? What can't I do? These are questions that have been occupying us in the past 2 or 3 months. We've got 3 different options really. You've got a scheme of arrangement that's under Section 210. You've got a judicial manager under the legislation. And number 3, you have liquidation. Now, what's the difference between a scheme of arrangement and a judicial manager? Effectively, I think there are 2 key differences. One is that with a scheme of arrangement, the directors are still running the company while putting together a proposal for repayment or for running the business. In a judicial management, what happens is that a third party is running the company, and this is largely because there might be concerns over the ability or propriety of the current directors running the company. A moratorium is needed to protect the company against any proceedings against it while it's looking to restructure. That is where Section 211B come in. So the purpose of Section 211B is to tide the debtor over until it's in a position to put together a broad scheme and get the court's permission. During this process of the moratorium, creditors can ask for the moratorium to be shorter, they can ask for conditions to be attached, they can ask for certain prohibitions. When a broad scheme has been prepared, then effectively we're looking at 3 steps for a scheme's flow. First would be the leave or permission from court to convene a creditors' meeting. Once leave has been granted, the creditors will then submit their claims and their claims will be adjudicated on. Whatever the value of the claims will then correspond to voting rights. We then go to step 2. Step 2 is when the meeting is convened by the debtor, calling the creditors to vote on the proposals under the scheme. Once that has been approved by the requisite majority, we move to step 3. Step 3 would then be the sanctioning of the scheme by the court. What are the considerations for a creditor when a company is applied for restructuring or before a company applies for restructuring? I think there are 3 separate stages. The first stage would be pre-restructuring, and this is before the debtor goes to court to apply for protection. I think at that stage, creditors should proactively reach out to debtors, find out, get as much information as possible. If possible, crystallize their security. If they have floating charges, perhaps crystallize it to fixed charges. The second stage is at the moratorium. When a moratorium has been applied, for example, under Section 211B, or where judicial management has been applied, there is a moratorium in effect, and parties often wonder what they can do and what they can't do. Generally speaking, enforcement against the debtor is now stayed. No enforcement of security can be commenced without leave of court. Now I stop at stress at leave of court because if you are a secured creditor, if you have assignments or if you have pledges in your favor, then I think the case can be made to apply for leave of court to enforce your security. I think the threshold for that really is to ensure that by enforcing your security, you are not prejudicing other creditors. A second line of questions we get from the moratorium stage would be whether parties can enter into new contracts with the debtor. And I think the answer to that is that it's really a question of a commercial payment risk. Where there are LCs or SPLCs open on behalf of the debtor in favor of counterparts, then I think that risk is actually quite minimal. The third stage would be looking at the proposal put forward by the debtor. And I think a lot of the times there is a financial report that accompanies the proposal that concludes with this one line that says that restructuring is more advantageous than a liquidation. No argument with that, but my point over here is to test that assumption that has been put forward. A lot of the times in trade finance, a company's assets arise from its receivables, and these receivables can be staggering sums, but they are at this point of time just pieces of paper. And I think a creditor needs to make an informed, assessed decision on how likely or how feasible recovery of these receivables are. You will have to look at where the receivables are due from, how long they have been due for, what sort of quantum it involves, and what sort of recovery process you'll have to undertake. I hope this session has been useful for you. If you have any questions, please feel free to reach out. I've also attached a link to a longer webinar on issues arising from restructuring. Thank you and have a great day.